Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 148. The issue is this, that if a company is amalgamated into another company, then the existence of the company ceases. And if the assessee already informs the revenue department that now this company is merged, amalgamated and this does not exist, and even then the department start proceedings against the company, so whether these proceedings are valid in the eyes of law or not. This issue has been taken up by the Bombay High Court in the case of Pico Capital Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 508. The case has been decided on 9th March 2023. The matter relates to the assessment year 13-14. In the present case, the assessee has already informed the revenue that the company has been merged. It has been amalgamated. But the revenue issued the notice under section 148A clause B, that is the show cause notice, regarding the escapement of income and giving a chance to the assessee to show cause why the case of the assessee is not to be opened under section 148. The assessee replied to this notice elaborately. Although in those replies, the assessee did not specifically brought this factum to the knowledge of the revenue that the company has been amalgamated. After that, being not satisfied with the submission of the assessee, revenue issued the notice under section 148 to the assessee to take up the reassessment proceedings. The assessee filed the writ petition in the Bombay High Court by saying that this notice has been issued in the name of the non-existent company and the revenue was already in the knowledge that this company does not exist because it has been amalgamated. The assessee heavily relied on the judgment of Principal CIT versus Maruti Suzuki India Limited, which has been decided in 2019 and the matter has been reported in 416 ITR 613, which has been decided by the Honorable Supreme Court. On the other hand, it was the plea of the department that the assessee did not specifically highlighted the factum during the proceedings under section 148A clause B. Although the assessee has already intimated before that proceedings to the revenue that the company does not exist no more and it has been amalgamated. On the other hand, it was the plea of the assessee that the participation in proceedings would not operate as an estoppel against the law. So the moot question before the court was that whether in the present case, when the revenue was already in the knowledge that the company does not exist, so whether this proceedings under section 148 read with section 148A clause D should allow to be continued or not. Bombay High Court said that there is a established law which has been affirmed by the Supreme Court in the case of Maruti Suzuki that the proceedings against non-existent company should not continue. Friends, the takeaway from this case is that although when the company is amalgamated, the no objection is taken from the income tax department and the income tax department is already in the knowledge that the company is going to be amalgamated, but at the same time it is always advisable that as soon as the company is got amalgamated, first of all the revenue department should be intimated about this fact that the company does not exist no more. The benefit of this thing is that all those revenue departments will be barred by issuing the notices against the non-existent company, and the assessee can safely take the plea that we have done our duty of informing the revenue department. But if the assessee does not inform, then there may be a risk that the courts may allow the proceedings to continue. At the end of this video, once again I am repeating the name of the case. The name of the case is Pico Capital Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 460 IPR at page number 508. The matter has been decided by Bombay High Court and the date of the judgment is 9th March 2023. Thank you friends.